We will now begin today's conference with our first session of the day, titled General Overview of the Judgments Convention. May we invite our moderator, Dr. João RIBEIRO-BIDAOUI, First Secretary of the HCCH, and our four speakers, Dr. Andreas STEIN, Dr. Marcos DOTTA SALGUEIRO, Mr. Sun Xiaofei, and Dr. Marcelo Dinardi to the stage for our first session. Thank you.
Good morning, everyone. Welcome to this first session of the day. All the speakers in this panel were extremely involved in the negotiation and drafting of the convention. They all touched upon its drafting, so it's fair to say that they are all parents, or in this case, fathers of the convention. For the sake of time, I would invite you to read their biographies in the conference materials. I will also try, if time permits, to open the floor for some questions you may have, so start drafting them. It's not every day that we can ask questions to drafters of international treaties to really know what was in their minds. I also believe that the opening speeches and the video clearly expose the purpose of the convention, and therefore I would jump directly to questions to our panelists. I would start with Andreas STEIN from the EU. Against the backdrop of the opening session and the video, how would you describe the convention's salient features, as we described in the program, and particularly comparing with existing international, regional, similar instruments, and of course also national legislations?
Thank you very much, João, and a very good morning to everyone. Before I start, let me just express my gratitude to the hosts, the organizers of this conference, and in particular to our very generous hosts from Hong Kong. It's truly a pleasure and an honor to be here. Now, talking about the salient features of the convention, this is a pretty daunting task. It has been facilitated already by some of the remarks that were made, for example, by the Secretary for Justice. But let me just highlight the three main features that I would like to underscore. The first one is the breadth of scope of the convention. The second one is the very generous and recognition and enforcement friendly system that the convention establishes. And the third one is the system of indirect jurisdictional rules that underpin the convention. A few words on each of these three themes. The breadth of scope. Well, if you look at many of the other international agreements, in particular the Hague Conventions, they have a pretty targeted scope of application. You're talking about, to mention the most recent example, exclusive choice of court agreements. So that's a very important convention, but the scope is quite narrow, and the same goes for many other international conventions. Now, this one is, in spite of some exceptions to the scope, which have been mentioned, and we would have liked the convention to be even more all-encompassing. So there are some exceptions to the scope, but in principle, this covers all civil and commercial judgments, ranging from small consumer contracts to multi-million or billion-dollar transactions, covering both contractual and non-contractual litigation. So this is a very important feature, and I can compare this to what we have at the European level, where we have a multiplicity of instruments for judicial cooperation, but the so-called Brussels I Convention, which has a similar approach as the Judgments Convention in covering all civil and commercial judgments in principle, this is the cornerstone of judicial cooperation within Europe. And against that background, we hope that the Judgments Convention will become a similar cornerstone of judicial cooperation at the global level. Now, the second thing that I would like to briefly mention is the very generous and recognition and enforcement friendly nature of the convention. It does establish a common floor for recognition and enforcement of judgments across the planet. But it is not exclusive. It leaves all the flexibility for parties to engage in other, even more generous bilateral or international agreements. And with one very narrow exception, which is the exclusive indirect jurisdictional rule on immovable property. But that's the only exception. Otherwise, we have this flexibility and this nature of a floor. And I think what's really important and what's going to be the added value of this convention is not to, or let me put it another way, I think in every jurisdiction it's known that with some other countries you have privileged relations, you already have a bilateral agreement, or the other state has a very welcoming approach to recognizing and enforcing foreign judgments. You don't need a global convention for those relationships. You need the convention for relations with other states where you have no system at the moment. That's, I think, where the convention will play out for the most part. And so that you're not left to the vagaries of national law of the requested state as to the extent to which it recognizes and enforces foreign judgments. And here again, I can speak from experience, because even within Europe, where we have common rules internally, when we're talking about third countries, it's every member state of the EU that creates the conditions. And even in some of our own member states, there is a very rigid approach to recognizing and enforcing foreign judgments. In some EU member states, at least theoretically, there is no recognition and enforcement of foreign judgments. You have to relitigate to some extent in order to enable the recognition and enforcement, or not, the enforcement of a foreign decision. So the third feature is the international jurisdictional approach, and I think that's a very noteworthy feature of the convention, because the way you deal with the jurisdictional issues was probably the biggest bone of contention in the whole process of getting the convention adopted. Now, there are several possible approaches to this, and before turning to the international, to the system of the convention, I will first say what the convention isn't, rather than saying what it is. If I look to my own home country, to Germany, to the national rules for recognition and enforcement of foreign decisions, what you basically do is you have a cross-reference to your own national rules. So if Germany looks at whether or not to enforce a foreign decision from a third non-EU country, it asks itself the question, well, if the foreign court applied the German rules of international jurisdiction, would it have had international jurisdiction? So that's an approach that obviously isn't fit for an international convention, but it's pretty widespread in a number of jurisdictions. The other approach that we see internationally is something that is based on a very general principle, and running the risk of venturing onto territory where I'm not a seasoned expert. For example, in the US, the whole case law on recognition and enforcement of foreign decisions was based on the principle of international comity. So you don't have detailed rules, you have a very general principle. And of course, from the perspective of legal certainty and predictability, that's something that would have been difficult for an international convention. So that's not the approach the convention has taken. The third approach, and there it gets a little more difficult, is direct rules of jurisdiction. So you combine a recognition and enforcement system with another set of binding rules that actually do determine the courts of which state contracting party are competent. And that's where the main difficulty resided. That's the system that we know in Europe. And of course, it facilitates things quite a bit, because once you have common rules for jurisdiction, you can rely on everyone else having applied those rules. So in principle, you don't need a test of jurisdiction at all. And within the EU, it's even prohibited for one court to test whether the other court had international jurisdiction, with some very limited exceptions. So from a European perspective, that's what we would have liked to see also at the global level, but as it turned out in the process, that was possibly a slightly overambitious approach. So what we have in the convention now is a system of indirect jurisdictional rules, which, if you look at them, You know, if you look at Article 5 in particular, it's a very long and detailed list. And to the non-initiated reader of the convention, it could look like those are actually rules of jurisdiction that apply internationally, but they're not. Because every court and every contracting party is free to adopt its own jurisdictional rules only when it gets to the stage of recognition and enforcement in order to verify whether the judgment was handed down in a proper forum. Then you have to run through those jurisdictional grounds and see whether this was actually a proper forum. Now, this is a somewhat complicated approach because the court in the requested state has to investigate issues that may not have been relevant for the initial court because it may have based its jurisdiction on completely different considerations. But we think that this is it's a manageable approach. We think if we look at the rules, they're not unmanageably complex. Some things will always be complex, whether it's direct or indirect. And there again, I can tell you that in Europe, after 50 years of applying the Brussels Convention and Brussels regulation, there are still judgments every year on what's the place of performance for a contractual obligation or what's the place where harm was caused in tort. So some things, that's why we earn our bread and butter as lawyers. But for the rest, we think the list is very straightforward and reasonable, and I will end on this note. Thank you.
Thank you very much, Andreas. It was quite helpful, this introduction to the convention. Let's turn our attention now to Marcus. You come from the country where the first treaties on private international law ever in force and still in force were negotiated back in 1888 and 1889. Even before the HCCH was established, actually. And you are also coming from the first state to sign the convention. You were also referenced to in all opening speeches, so big responsibility. With this powerful perspective in mind, can you guide us through the origins of the judgments project, building up also a little bit on what Andreas said, and highlight what is for you the main objective of the convention? And of course, also, what would the convention mean for your region, given that there are several instruments on private international law already in force there?
Thank you very much, João. Shou-san, good morning to everyone. It is a real pleasure and an honor to be here and share this panel with such dear colleagues and friends as João, Andreas, Xiaofei, and Marcelo. Many thanks also to the organizers, the Hague Conference on International Private Law, its regional office for Asia and the Pacific, the Department of Justice of the Government of the Special Administrative Region of Hong Kong, and the Asian Academy of International Law for their invitation and allowing me to be here coming from far, far away. As João mentioned, Uruguay is proudly the country where the first treaties on private international law ever in force and still in force, the Montevideo Treaties, were negotiated and signed, and also the first country to sign the new convention. The origins of our convention date back to 1992, when a proposal was made to undertake work on uniform rules on both jurisdiction of courts and the recognition and enforcement of judgments in cross-border cases in civil and commercial matters. For different reasons, after a diplomatic session held in 2001, both issues were considered separately. This led to the adoption of the 2005 Choice of Court Convention, while in 2011, the Hague Conference agreed to consider the feasibility of a global instrument on matters relating to jurisdiction and the recognition and enforcement of judgments. An experts group met in April 2012 and concluded that further work on cross-border litigation was desirable. A working group was established and met on 5 occasions from 2013 in order to develop a draft text of court provisions. This working group presented a draft text in October 2015, and after that, 4 special commissions meetings were held in June 2016, February 2017, November 2017, and May 2018, arriving finally to the diplomatic session that adopted the convention last July 2nd. From our perspective, the main objective of the convention could not be better described as it is in the second paragraph of its preamble, and I quote, "To promote effective access to justice for all and to facilitate rule-based multilateral trade and investment and mobility through judicial cooperation," something that is complemented with two core concepts in its fourth paragraph, predictability and certainty. For our region, the convention means a possibility of deepen our own cooperation, but also and especially the opportunity to open the scope of countries with whom cooperate worldwide. For those of our countries that, as Uruguay, have already in our international private law rules a mechanism for the recognition and enforcement of foreign judgments not subject to reciprocity, it is an opportunity to obtain the recognition and enforcement of our own judgments in countries whose judgments we already recognize and enforce, even without a convention between our countries. So that's perhaps our approach to your question, João.
Thank you, Marcos, for that. And now that we understand a little bit its purpose, the importance, and how we got to this point in history, and also its salient features from your perspective, Xiaofei, what are in theory and also in practice the main advantages of the convention, but for states? And I will ask each of the speakers from different perspectives of different stakeholders, but I would start by asking from the perspective of states, how do you see as being the main advantages of the convention?
Thank you, João, and good morning to everyone, and also many thanks to everyone to make this conference possible. So it's really a good honor for me to have the opportunity to be here to share some of my personal thinking points. And also I feel very excited and also emotional when I saw maybe someone just like me moving around in the video. So really excited and emotional. And just for your question, João, so from the perspective of the state, I do think I can answer your question from maybe in three ways for the advantages of the convention. The first one, I think it should be the predictability. Enforcement and recognition of the judgment, we say IEJ, is an essential part of the judicial cooperation. And it is really necessary and important to have rules in place to facilitate this kind of cooperation. And for the convention, it established a set of rules in a very comprehensive and systematic manner. And just as introduced by Andreas just now, I quite agree. And I do think where there is a rule, there is a way. So I do believe the convention will provide a very meaningful and practical guidance for not only judges at the state level, but also for the companies and individuals who are carrying out their civil or commercial activities. I'm looking after mutual legal assistance, sorry for that. And the second advantage, I think, would be the progressiveness. Whenever we are looking at the international rule, we are always wondering whether this rule is good or not. So I would say that the convention is a very good one. And because it reflects the needs of the time and also can address the different concerns of the country. So I do think, you can find out all these all throughout the convention, especially when you read the preamble of the convention. It says one of the main purposes for the convention is just to facilitate the rule-based multilateral trade, investment, and mobility through judicial cooperation. So for the third advantage of the convention, I think it should be the flexibility. I have been working in the area of the judicial cooperation for years, and my very strong feeling point is that the main obstacle for the judicial cooperation would be the differences in the various legal systems. And the convention is so successful is because it can, address the different concerns, different interests of different countries. They have different rules or different systems. And in this way, we can bring everyone together. And we have lots of discussions over the past negotiations. And fortunately, we got a compromised outcome in the diplomatic session, by everyone's joint efforts. So you can also find some details in the articles of the convention, like the Article 2 specify the exclusions from the scope. Although the list is still very long, but we will try to make it shorter and shorter. And also for the Article 7, for the refusal grounds, we can see the respect for the public policy and the security and the sovereignty of the states, and also some flexible mechanisms in the Chapter 3. I think all these flexibilities will encourage the states to accept the convention as much as possible. So that's the three advantages in my mind now.
Thank you very much. And Marcos, what about the advantages for companies, corporations, and also for citizens?
Thanks, João. Yes, perhaps the first advantage of the convention to citizens and companies is related to something that Andreas has already mentioned, the breadth of scope that is translated in the real world in a great variety of situations covered, from a tort to international sale of goods. Another advantage is that there is a special provision in Article 3.2 that defines when an entity or person other than a natural person, as companies, shall be considered to be habitually resident in a state. And there are many options to that end, what means in practice that many connecting factors apply in these cases, such as where it has its statutory seat, where it has its central administration, where it has its principal place of business, or under the law of which it was incorporated or formed. But perhaps the advantage for citizens and companies that I like more of the convention, both from a theoretical and from a practical point of view, is that it has, as a general rule, only subject to declarations, the traditional principle of not asking for a cautio judicatum solvi, based on the nationality or the domicile or residence of a party. In this sense, according to Article 14.1, and I quote, "No security, bond, or deposit, however described, shall be required from a party who in one contracting state applies for an enforcement of a judgment given by a court of another contracting state on the sole ground that such party is a foreign national or is not domiciled or resident in the state in which enforcement is sought." In other words, this provision ensures that the non-discrimination principle for foreigners in the state where the recognition and enforcement is sought, because if a security, bond, or deposit were requested to foreign citizens or companies on the sole ground of their nationality, the whole goal and spirit of the convention would be simply undermined, and the convention would only be a beautiful law text without practical effect and results. So these are for me the...
Thank you, Marcos. And Marcelo, what would you say would be the advantages for legal professionals, which I anticipate it's almost everyone in this room?
Good morning, everybody. Thank you, João. Thank you, Andreas. Thank you, Marcos and João. And please let me speak standing, because I'm receiving the shine of your intelligence, but I'm eclipsed by this thing, and part of the audience is not seeing me. So, excuse me. Can I? Thank you, everybody. Thank you for inviting me here. Well, let's set foot on land then and put our hands on dust. How would we use this? And this is the thing that I believe it's the most expected, and for you practitioners would be the needed thing to understand. My envisage now, which is quite abstract one, is that something that João used the word predictability, This is the thing that would be the best for the actual practitioner on international dispute resolution. This said, the idea of having some more concrete and more reliable rules, this is the thing that Andreas said, addressed this, would be diminishing the costs for the purposes of negotiating. And certainty that comes from this predictability would be, of course, an enhancement to an international trade. And let me get something that also Andreas mentioned in his initial presentation, that the convention deals also with non-contractual responsibilities, non-contractual obligations. And this also entitles or demands the litigation planning, the litigation envisaging of what would happen after the judicial dispute. So this would be something that really helps, or maybe doesn't help, depends on the side where you are, because you can prevent being responsible for something using the, well, the difficult multiple rules that we have nowadays. If we have one and only reliable rule that everybody understands, would be much more easier for the ones that are creditors for a judgment. So this is the main goal that I believe, following Andreas, that we achieved in our proposal, legislative proposal. And once it gets in force, it will allow you, for you practitioners, to get, envisage the future of the outcome of the judgment and the recognition enforcement abroad. This will be the main expectation from me for the actual practitioner. As a judge, I would expect also that this kind of rule would be properly used by the counselors and properly presented, and would demand from the judges to make the work, especially on the actual litigation, not the recognition and enforcement level, but in the actual litigation, envisaging this kind of effectiveness abroad, out of the jurisdiction that he's actually playing his role. So this makes things much more easier for the judge to have one rule to understand and not a bunch of rules for every and each case that comes, and I need to learn from Hong Kong SAR, China mainland, and other jurisdictions for the sake of understanding how should I write my opinion in order to be able to be recognized and enforced abroad. So predictability, the easiness to understand would be, for me, the actual benefits for the practitioners. Thank you.
Thank you, and also for helping me keeping the audience awake. Andreas, the EU, and actually in particular you personally, as was clearly attested by the video, were deeply involved in the negotiation. And allow me this two-part question. First of all, how important are the choice of court that was briefly mentioned and the judgments conventions important to enable cross-border business-to-business more broadly? We talk a lot about this, but how really does it enable it? And therefore, to a certain point, help this new generation of EU trade agreements to succeed. You have, if I'm not mistaken, trade agreements in force with Canada and Korea, and soon to enter into force again, if I'm not mistaken, with Singapore, Vietnam, and Japan. So how the convention can enable a cross-border business-to-business in this context. And the second part of my question would be, how do you see these conventions as serving a useful purpose, namely for EU candidate countries, especially at the early stages of that process, or also countries of what is called in Europe the European neighboring policy, and how these conventions provide somehow a first contact with standards also adopted by the EU and therefore somehow facilitating legal integration, help to diversify legal education in these countries, and in the end also enhance judicial cooperation.
Thank you, João. On the first part of your question, the link between the convention and free trade agreements, I think the colleagues have already spoken extensively about the advantages of the convention from the perspective of states, parties, and legal professionals, so I don't have to go into that again. To me, it's quite trivial almost to say that with increased trade, which is the very objective of facilitating trade relations, there will be more interaction, there will be more transactions. With more transactions, there will be more litigation, and there will be a bigger role for the rules on judicial cooperation. Actually, your question gives me an opportunity to come back briefly to something I already said in the opening remarks to the diplomatic session in June, and that is to look back at the history of the EU, which at its inception was also essentially a free trade area. It was even referred to very commonly as the common market. It was unthinkable that the EU would ever have competence to regulate questions of private international law or related matters. Yet, I think the founding fathers and mothers of the EU had a very visionary thought when in the founding treaties they included a provision that said, although your organization is not responsible for that, member states are encouraged to engage in efforts to conclude a convention between themselves that will facilitate the recognition and enforcement of judges between themselves. So it was realized at that time, and that's 60-some years ago, that a system of judicial cooperation is quite a crucial component of a free trade system. And I think we're following up to that now at the global level with this convention. When you look at free trade agreements, including the EU free trade agreements, including the very recent ones, you will see that they have no provisions on judicial cooperation. So this is left out of the formal framework of the free trade agreements themselves, but that makes it all the more important, in my view, to have a complementary system such as the one we have now created with the convention. On the second issue, EU candidate countries and neighborhood policies, just very briefly on candidate countries, so countries with a concrete perspective to become an EU member state. I think the convention will not have a very strong role in that particular context, and there is a simple reason for that. When a country prepares for becoming an EU member state, it will approach adopting the EU standards as well. So what they should and will use as a blueprint is the EU rules on judicial cooperation. Of course, if a country joins the EU after the ratification of this convention, upon accession to the EU, it will be automatically bound by the Judgments Convention as well. So it might even be a bit counterproductive to force them through a ratification process individually, although they're already candidate countries. So I don't see a very strong role in relation to EU candidate countries, but things are very different in the neighborhood policy. And to illustrate that, I've looked at the recent association agreements that the EU has concluded, one of the most recent ones being the one with Ukraine. And I will just quote a provision to you, which is called legal cooperation, and has the following second paragraph. The parties agree to facilitate further EU-Ukraine judicial cooperation in civil matters on the basis of the applicable multilateral legal instruments, especially the conventions of the Hague Conference on Private International Law. So there is a recognized role for the Hague Conventions in that particular context. We are promoting and spreading accession to the conventions through this neighborhood policy. And of course, the Judgments Convention will occupy a very prominent position in that context.
Thank you, Andreas. And now back to Asia. Xiaofei, China was also, and we also saw that in the video, one of the most active participants in the negotiations, and it also contributed to several, and substantively to several informal working groups. We hosted 2 meetings also here in Hong Kong. How should the rest of the world read that commitment to a multilateral treaty on recognition and enforcement of foreign judgments? And why is this convention so important for China? We heard it a little bit during the opening session, but I would like to hear from you. And also building up of what was mentioned in the opening session, again, how important was the convention for the negotiation of the arrangement between mainland China and Hong Kong SAR?
Thank you, Joel. And for your first question, I would like to respond from a broader perspective. And China's active participation is only a tip of the iceberg, if you think about this in the context of the 32 years long cooperation between China and the HCCH. And the Chinese government highly value the relationship with HCCH and have been constructively involved in the major events of HCCH. So just to take the judgment project, for example, China is one of the parties who took part in the negotiation at the very beginning in 1992, and then on the Convention of the Choice of Court of Agreement, and then the current convention. So you will see the commitment of China all the way. And also we have a working group meeting this February right here in Hong Kong to further advance the negotiation right before the diplomatic session. And also today, the big event, another commitment of China. So I will say that China's commitment is not only for today, not only for the judgment project, it's for the overall cooperation between China and HCCH. So that's the first question. And the second question, I think the answer may be very simple. So if a judgment cannot be recognized or enforced, it is nothing but a piece of paper. So, for China, in order to have cooperation on REJ, we have concluded 39 bilateral treaties on mutual legal assistance in civil and commercial matters, and 35 of which they include the article of REJ. But that's far from enough. So just as mentioned by our Director-General Jia in the opening speech, the convention will be a golden key to the international circulation of the judgment. And it will also be a very important key for China to open the door for a further REJ cooperation. For your third question is with regard to the arrangement between mainland and also the Hong Kong SAR with regard to the REJ cooperation. That's a very interesting question, and also it's already mentioned and detailed by Honorable Secretary for Justice just now in the opening speech. When we are discussing the arrangement, we just used the draft convention as a model test. And of course, at the same time, we made some changes adapt to the concrete situation between mainland and Hong Kong. Now the new convention is already adopted and bringing in new ideas and articles. So, I would like to leave the question or leave the judge to decide whether to make some improvement or amendment or not. So that's my reflections for some of the idea for your question.
Thank you, Xiaofei. Marcelo, as a judge and also as a renowned Brazilian professor, what kind of impact do you think the convention will have on something that there's a growing conversation about, on dispute resolution strategy and planning? And let's say that the Brazilian Chamber of Commerce asks you to come over to deliver a lecture or a briefing on the topic, and one of the general counsels of a major Brazilian company asks you very directly for a preference. What would you recommend? Would you recommend an exclusive choice of court clause, for instance, choosing one of the many available international commercial courts? Would you recommend a multi-tier dispute resolution clause, or you just recommend a silent contract and use litigation as a fallback?
Let me check if this is while I'm sleeping. Thank you, João. Thank you again for this question. And I hope this happens a lot. I like to understand and to entertain with those people, the petitioners, because it gives me the feeling of the actual thing happening. Let me add a few notes to the previous mentioning. The Mercosur has, a month or two ago, finished negotiation of a free trade treaty with EU. It's entering now the mutual ratification period of time that is expected to take 2 to 5 years in good condition, but there is also a media war going on this. Well, that was mentioned before by Mr. Reza, something like that. We have, Brazil has also international cooperation, judicial cooperation treaty with China mainland, and to my understanding it's in force. And it doesn't deal as deep to the international judicial cooperation as this convention, the Judgments Convention deal, that establishes the commitment to recognize and enforce, but not in a deep and specific regulation as Andreas described it as before. So we have a path to go through. But on the precise question that João asked me, I believe that we need to split the contractual relationships in two, at least, levels of commitment related to the economic value of the contractual relationships. And this makes the difference between using the arbitration or the judicial litigation option. This will be my answer to the General Counsel of a great enterprise. This makes a difference, and the value would be, for Brazilian standards, around $2 million, $2 million American dollars. That will be the lowest level of economic efficient arbitration for Brazilian standards in a contractual relationship. Less than that, I would not recommend, of course, arbitration, because the cost will be overwhelming in relation to the actual gain that you can get. So this makes the first separation of situations that would will lead to an option. And following that, I will recommend the use of an arbitral clause with multi-tier, with mediation before that, and going up until the end, if not resolved, to arbitration, with general chambers of arbitration that are available in the world, even here in Hong Kong, to my knowledge. So there is a number of alternatives, and also the specific understanding that arbitration can set for the procedural rules also within the parties' will. So this is may be very important. On the lower side of the values, I would recommend the use of judicial dispute resolution with a multi-tier clause going from mediation up to the last level. And of course, associated to that, the choice of court in international contracts, using one of the emerging international dispute resolution, judicial dispute resolution courts available. And depending on the subject of the contract, the kind of relationship, the objects would recommend one of the specialized courts around the world. UK has a lot of them. The cotton, to my understanding, the sugar is also there. And it depends on the subject of the contract. So this would be my advice, to split the situations in two: on the value, on the higher level, to use arbitration at the end of a multi-tier clause, and the lower level use judicial in a multi-tier also clause with the choice of court, exclusive choice of court, for the purposes of making it predictable. One thing that is very important to understand, and we tried to collect, Professor Nadia de Araújo and I conducted a survey with Brazilian practitioners. We found that the predictability would be a value for this kind of recommendation, solution, or practice, actual practice, on the international prevention of litigation or intellectual contractual negotiation. And this was an outcome. The certainty and predictability available through this convention would raise the level of importance and the acceptance of the judicial settling of disputes to nearby the level of acceptance of the current level of acceptance of arbitration. So this will be in terms of my answer. Thank you.
Thank you, Marcelo. And now I have a question to all of you. All your jurisdictions are involved one way or the other with the Belt and Road Initiative, and all of you come from jurisdictions which are founding members or prospective members of the Asian Infrastructure and Investment Bank. And AIIB plans to invest 3.5 to 4.5 billion US dollars this year alone on sustainable infrastructure, cross-border connectivity, and also private capital mobilization. So several academics and also think tanks, policy think tanks, identify always legal risks as a key obstacle, if not the key obstacle, to the pursuit of the strategic goals of the initiative, but also of the bank. Do you see the Judgments Convention as making a tangible and also a meaningful contribution to reduce these risks and help the operation of the initiative? And if so, can you explain what type of contracts, giving examples of existing projects, would fall, in your view, under the scope of the convention? Also, of course, bearing in mind the jurisdictional filters, the subject matter, but also having in mind matters related to state-owned enterprises. I think protocol means that I need to start by you, Xiaofei.
Thank you, Joe. Thank you for mentioning the Belt Road Initiative, we call it the BRI. So may I first introduce some background for BRI. The BRI is a kind of international economic cooperation initiative aiming at to further facilitate cooperation between countries in the economy areas, and also to open new space for the economic growth. So generally it's open and inclusive and follows the rules of equality and also mutual benefit. And over the past 6 years, since it's first raised by our President Xi Jinping, we have maintained a very good and strong momentum on BRI. And we have held 2 big forums on the Belt and Road International Cooperation. And also the HCCH is also involved. And just to take the recent forum that happened in April, for example, we have nearly 6,000 delegates from over 150 countries and 90 international organizations. So you will see the BRI is developing very fast and is well welcomed by countries and organizations. So you can foresee, and in the future, not the near future, but also the far future, the BRI will bring, more and more business to business and people to people interactions. Of course, at the same time, we realize that the disputes of the business and the investment is very common and sometimes is unavoidable. So the legal cooperation will be essentially important for BRI. And I would like to let you know that last year in July, our Ministry of Foreign Affairs held a forum on the Belt and Road legal cooperation. There were 400 delegates from over 50 countries and organizations attend, and also the Honorable Secretary-General was invited to honor the occasion during that time. And so you will see the convention, as a resolution for the dispute in the litigation area, will have play a greater and bigger and more important role in this regard. So personally, I do think the convention have a better and broader ground to have much more things to do. So I do understand maybe litigation is only one of the options on the table for the companies or individuals to pick up. But we have just discussed the advantages. So I do believe, together with the advantages, I think our convention will prevail to some extent. Thank you.
Thank you, sir. Andreas, what would be your take on this point?
Thank you, João. Well, I can pick up on where Xiaofei left to quite a large extent. I think every international transaction, whether it's within the context of the Belt and Road Initiative or in any other context, implies a pretty complex risk assessment exercise. The legal risk of not being able to have a decision recognized and enforced is obviously one element, but an important element of that risk assessment, and the convention will play an important role in reducing or eliminating that risk. Now, I'm not in a position to make particular predictions on particular types of transactions, and I think that's not my role, and that's the point that I wanted to make, is that it's not up to us to consider what's the most appropriate channel for dispute resolution. It should be open to parties to decide what the most appropriate channel would be in that context. And in that context, the Judgments Convention just adds an option that in a number of cases didn't exist before. So on a number of types of transactions so far, arbitration has been the only safe option, if being a pretty costly one in relation to the value of the contract that you're talking about, and where there was possibly only one safe option in the past. We may have an additional option, an alternative, to engage in litigation through state courts. And I think that's the important point that I would like to make. Leave it to the parties to decide these things. Do not have one option eliminated simply because there is unpredictability as to whether a court decision could ever be recognized and enforced in another state. And now, to give you my personal sort of estimation on what will happen, again, I think I agree with Marcelo that the value of the transaction will be the most important indicator. I would expect that for very large transactions, and often infrastructure, and Belt and Road Initiative is to a large extent infrastructure, are large transactions. I would expect parties to resort to arbitration as the preferred dispute resolution mechanism for those large projects. For things that are still very voluminous in size, but not as large, I think the convention really fills a gap and will become very important in practice. But that said, recently I've heard some noises about the arbitration market, if I may call it that, overheating a bit and costs partly spiraling out of control. So against that background, maybe even for larger transactions, you know, in a borderline zone between, depending on what the value is, the convention might inspire some competition, some healthy competition between either arbitration or litigation before state courts in states where there is a very efficient and performing judicial system.
For the sake of time, I'm going to jump to the last segment of our session. And I know, Marcelo, that you came all the way from South America specifically to ask a question in front of all these people to Andreas. I know you spent the whole night preparing this question, so let's hear it.
Thank you, João. And I'll talk also to my hard colleagues here on my left side also. Hi. And Andreas, please. I was proposed by, suggested by João to ask you a question connected to Article 29, very difficult negotiation within the convention. Everybody here in this standing had interventions on this. Article 29 came to light right after the conclusion of the Special Commission and before the last stage of the process, the diplomatic session. And apparently contravenes the general idea of cooperation, mutual respect and confidence that informed the development of the judgments project, at least since 2014 to my testimony, my personal testimony. Coming from a regional economic integration organization, to use the expression in the convention, that needs to deal with these issues on a daily basis, because it is not easy to deal with 27, 26 different jurisdictions. Do you see this provision as a risk for the general acceptance and further development of the convention's community, not with a closer in time perspective, not in the immediate politics, but for the long run? Will the lack of confidence between contracting states expressed through the use of the power enabled in Article 25 create prejudice among states? How do you value these contradictory possible views of the future of the convention? I read it. Yeah. Thank you.
Thank you, Marcelo. So Article 29 is the provision that establishes a mechanism by which contracting parties are enabled to object to another contracting party upon accession or within a certain period after accession. I would start off by stating that this is not an altogether new provision for Hague Conventions. There are a lot of conventions that have objection clauses pretty similar to the one that we see in Article 29. We have some other Hague Conventions that have acceptance clauses, so it's even more cumbersome. You have to perform an active act of accepting another state. So we see this quite a bit. What's the real novelty in Article 29 is that, unlike in the past, this objection possibility exists with regard to every other exceeding contracting party to the convention. In the past, this only applied to accessions by countries that were either not members of the Hague Conference and or that hadn't been present at the diplomatic session concluding the convention in question. So actually what you had in the past was an approach that was based on a distinction between what I would call an inner circle, where there is no possibility to object, and an outer circle of states that are in a weaker position and could be objected to. I think this older approach, as I would call it, dates back to a period where also the Hague Conference as an organization had a much more restricted membership, and may I say a somewhat Eurocentric structure of membership. With the increasing universality of the organization as such, the situation has manifestly changed, and I would argue it has changed for the better. But I think with that universality, this old approach also has become somewhat outdated. So I think in that new situation, there were basically two possibilities. Either you make the convention a fully open convention without any possibility to object, or you have an approach that enables an objection without the discrimination between the inner circle and the outer circle. Now, the EU has not asked for the type of objection mechanism that we currently have, or that we have in Article 29 of the Convention, but I think the provision as it now stands seems a reasonable solution to me. From an EU perspective, the thing that we wanted to avoid at any cost was any such provision that is so cumbersome and sensitive that it would turn into a danger for the success of the convention as a whole. And I'm not saying that without reason, because the previous attempt to have a worldwide judgments convention in 1971 established an extremely cumbersome mechanism of having to enter into bilateral relationship with every other contracting party through a separate agreement, and that is commonly held to be one of the reasons, if not the main reason, for the failure of that convention. So we wanted to avoid that at any cost. But that's not what the text as it stands says. We have an objection mechanism, which means the default solution, if you don't do anything, is you accept the other contracting party, and that is somewhat that is something that we can live with. I also wouldn't interpret this provision as a general sign of mistrust. I think it depends on how it's going to be applied. The philosophy that we would like to apply to this is that this is really an emergency brake that you should use in really exceptional circumstances, and that is certainly the way the EU will apply this provision. And I think if it's applied in that spirit, it will not endanger the success of the convention. Quite on the contrary, I think in the ratification process, in states, the mere existence of having such an emergency brake, if only for exceptional solutions, could something that also facilitates the acceptance and ratification of the convention. So on balance, we think this is an acceptable solution.
Thank you very much, Andreas. And to wrap up, and very briefly, Siofe, I know that you also prepared a question to Marcus to ask him why he made many of us in this room to work extra time during the diplomatic session in relation to Article 4.2.
Okay, so my question is for Marcus. And the Article 4.2 reads, there shall be no review of the merits of the judgment in the requested state. There may only be such consideration as is necessary for the application of this convention. So could you please give us some general idea for your understanding of this article, and from a practical point, do you still see any risk can mislead the judges in practice? Thank you, Marcus.
Many thanks, Xiaofei, for your question and for raising this important issue that for us is at the core of the whole convention as one of its conceptual pillars. And that's why Uruguay was the nightmare of many of the delegates during the diplomatic conference. In fact, we understand that this provision of Article 4.2 that you have just read states something that is implicit in Article 4.1, because if a judgment shall be recognized and enforced under the provisions of the Convention, it is because we are referring to a decision on the merits, as is defined by Article 3.1b. So if we didn't have an exclusion of the review of the merits, we don't have a recognition and enforcement of a foreign judgment. There could be little purpose to the Convention if the court of the requested state could review the underlying factual or legal basis upon which the court of origin reached its decision. For us, private international law is a law of tolerance and respect, and the no review of the merits is part of the respect due to the courts of the state of origin. The good news on this point is that the discussion held during the diplomatic conference and also before during the special commissions didn't take place as a result of differences on the policy, but only on the best way to state the policy as clear as possible for everyone in the convention. Uruguay and many other supporters consider that the first sentence of paragraph 4.2 was enough, but taking into account the importance that for some delegations had the second part, we arrived to a consensus formula for the second sentence as a very general endpoint for other articles that in any case have their own ground of application. In addition to the text itself of Article 4.2, that is a very improved version from the original draft, and the minutes of the diplomatic conference, the explanatory report is being very clear on this respect, so I don't think that there is any risk of misunderstanding on this regard, or at least I hope so. Thank you.
Thank you both, and we will not have time. I will not fulfill my promise to open the floor, but if you have drafted the questions, please take the opportunity of the coffee break to address them to our speakers. To wrap up, I would ask each one of you to share with us one word and one date, one word that encapsulates what you feel about the convention, and one date as the year that you believe the convention will be in force in your jurisdiction. Marcelo. I should say that it's being recorded, yes.
Thank you for this late warning. Reciprocity is the word, especially for Brazil. And I expect it to be enforced in Brazil not earlier than 2025.
I'm going to write that. Andreas.
Thank you. Well, when it comes to the word, although the Secretary-General of the Hague Conference always finds catchy words and has used the word game changer, I could just repeat that. But in order to be original, I would say something like quantum leap.
That's 2 words.
Yeah, you maybe hyphenate it. I don't know. You can reduce it to 1. On the timing, well, ratification is a complex matter in individual states. The EU is not an individual state. It's an organization of 28 as of today. So that implies an enhanced complexity. I don't want to put a date on things. I think Mr. Gia has already said that China is in the process of launching a study. I can tell you that for us to make the legislative proposal for accession, we have to go through a lengthy, I would even call it excruciating, preparatory process, including an impact assessment that requires a study. What I can tell you is that we haven't dragged our feet. We've basically started the prep work for this exercise immediately when we came back on the 3rd of July from the diplomatic session. And in general, my advice for everyone else would be, don't worry about us, but don't necessarily wait for us either.
Well, thanks, João. With respect to the word, I could say milestone. This is a milestone for every one of us. And in relation with the timing, well, I have at this time 11 hours of jet lag, so whatever I say is not enforceable in Uruguay at all. But let's say that it's reasonable 2021-22. Thank you.
So if I have one word I'd like to choose, cooperation, without which we cannot come such a long way and get a very fruitful result. And for the date, I would say that it's really a difficult and sensitive issue, especially when my boss is sitting right there. So I would say I haven't got any instruction from my boss, so the only thing I will tell you is the date when we finish our internal procedure. Thank you.
Thank you very much to all. Please hand to our speakers and enjoy your coffee break.